in an important First Amendment case that in which oral arguments were heard yesterday, talking about Missouri v. Murphy, of course. We've been talking about it for months and months. One key exchange was between Justice Ketanji Brown Jackson and the Louisiana Solicitor General. Listen to this exchange because I think it's really it's sort of a disturbing perspective Jackson is telegraphing about our First Amendment freedoms.
Biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And, Your Honor, I understand that instinct, and I guess what I tell you is our position is not that the government can't interact with the platforms there. They can and they should in certain circumstances like that present such dangerous issues for society and especially young people. But the way they do that has to be in compliance with the First Amendment, and I think that means they can give them all the true information that the platform needs and ask to amplify that.
Right, but you're just saying that. I guess I thought when you say the way they do that is consistent with the First Amendment is that they have to show that they have a compelling interest to do what they're doing. In other words, you want us to take the line to be between compulsion and encouragement. And what we're looking at is the government can't compel, maybe they can encourage. I'm wondering whether that's not really the line. The line is, does the government, pursuant to the First Amendment, have a compelling interest in doing things that result in restricting the speech in this way? That test, I think, takes into account all of these different circumstances, that we don't really care as much about how much the government is compelling, or maybe we do, but in the context of tailoring and not as sort of a freestanding inquiry that's overlaid on all of this. Does that make sense?
It does, Your Honor, and I apologize for missing your guidance earlier. So the way I think about that is I've been discussing the standard, and I thought we've all been discussing the standard on the front end of the analysis, which is there a First Amendment violation? Is there an abridgment of speech? I guess I would conceptually think of strict scrutiny, narrow tailing, compelling interest as coming in at the back end to say, yes, maybe in the ordinary case, the government shouldn't have been permitted to undertake the kind of suppression of free speech that it did, but in this unique circumstance, it actually had a compelling interest, and it used narrowly tailored means to accomplish that interest. I mean, I think that's the fail-safe. If you're concerned with the breadth of our arguments, that's one fail-safe, which is no matter how broad the standard the court adopts, there's always going to be strict scrutiny at the end of the line to save the government in times where it desperately needs to do the things that you're outlining.
Thank you.
Thank you, counsel.
Michael Schellenberger noted that he worried about this being a predicate to state censorship or greater state censorship, and so do I. Schellenberger, of course, one of the Twitter Files reporters. For more on this, please be joined by Jed Rubenfield. He's a professor of law at Yale, an expert on constitutional law and First Amendment rights, also the author of The Interpretation of Murder. Professor Rubenfield, thanks for joining us. Appreciate it.
Oh, happy to be here.
So isn't Ketanji Brown Jackson sort of insinuating a more expansive prior restraint power for the federal government?
Well, the clip you played is one of the most worrisome, troublesome exchanges in an oral argument I've ever heard, and it was very disheartening to hear that. let me say a couple of things by way of real quick background. Number one, I'm a lawyer in that case. I'm involved in the litigation. Just full disclosure, Bobby Kennedy Jr. is a plaintiff in that litigation. I'm his lawyer. Just so everybody knows that I'm
Good to know.
a lawyer in that case. But
are you going to be his running mate as well?
Yeah, right. But what she's saying is she's invoking what's known as the compelling state interest test. And in exceptional cases, the government's allowed to, according to current law, is allowed to violate our constitutional rights in extremely exceptional circumstances if there's a so-called compelling state interest and what they're doing is very narrowly tailored. Mm-hmm. Now, you got to understand, the government itself did not argue that in this case. No one has argued, not even the government itself, that what it did could be justified under this compelling state interest test, because what they did was not narrowly tailored at all. And if Justice Jackson thinks that what the government did in this case, which is having like 80 to 100 analysts calling up the platforms several times a week and telling them what to take down, and pressuring them and working with them to censor protected speech, if she thinks that that's going to be something that the compelling state interest test can justify, we're all in big trouble. So that's a very worrisome thing. Even the government itself had not argued it, and I was very disappointed to hear Justice Jackson making that argument. I can tell you this. A couple of years ago, you could not say on Facebook, on Twitter, on Google, you could not say that the COVID virus might have originated in a lab in Wuhan, China.
Right.
Now, what compelling state interest did the government have in not letting people say that? All it was doing was pushing its own political agenda and stopping people from speculating about what turned out to be a very strong, plausible explanation of the origins of the virus, and the idea that the government can tell folks they can't say that, and that Americans were not permitted to say such a thing on the social media platforms for like 6 months in 2020. That was, it's what country we're living in, and that you cannot possibly get to the compelling state interest test to justify something like that.
Well, the other thing too is how the state went about pursuing this compelling interest that Ketanji Brown Jackson thinks it had. They didn't say we have a compelling state interest. We're calling on social media companies to make sure they promote the vaccine and they they don't platform theories about its origination in Wuhan or whatever, platform the mitigations and so on and so forth. It didn't do that. It did this surreptitiously, pressuring them behind closed doors, using state power, as some argued, maybe as Alito argued, we've got this Section 230 in our pocket, so you better go along. To the extent there was pushback, and oftentimes there wasn't, they were sort of colluding. But it wasn't, they didn't make this open and notorious that this is what we believe, and so we're acting under this theory. They did it all in a clandestine manner, which goes to, a belief, I think a reasonable belief, that they knew what they were doing was wrong. They knew they couldn't do it themselves, so they used a cutout.
Well, you're exactly right about that, and it's extremely important. Just so everybody understands, there's two things the government's not allowed to do in these contexts. First, it can't coerce, and that's what everybody was talking about at the oral argument, and that's kind of what you're talking about too. You can't threaten and say, look, if you don't do what we want you to do, we're going to, maybe pull your 230 protection, or maybe we'll come after you under the antitrust laws. That's called coercion. That's a threat. And everybody understands that the government cannot do that, and if they did that, which, they were found, the Fifth Circuit Court of Appeals found they did do that. Mm-hmm. And if they did that, that's unconstitutional. They cannot get Facebook to censor speech by threatening them. But the other thing that they can't do, and there was no talk about this at the oral argument yesterday, and it was very disappointing, they're not allowed to get in there and do what's called joint activity, a joint action. That is, get in there and involve themselves so closely that they become joint participants in the platform's censorship decisions, what particular stuff to take down, what censorship policies they should have. And there was tons of evidence that that's what they did. They got in there and they became co-partners. The platforms were even referring to themselves as partners with the government agencies in deciding what speech Americans could not say, what facts they couldn't dare to utter, what viewpoints they couldn't dare to express. And I was shocked that the lawyers didn't push that, and that the justices didn't see it, and because the Fifth Circuit Court of Appeals found that was violated too. That rule was violated too. There was joint action in this case, and I think we should have heard more about that yesterday as well.
Well, you can't suspend the Constitution because they said COVID's a once in a lifetime event.
People who want to suppress free speech always want to suspend the Constitution. That's what the real problem with Justice Jackson's line of thought is. Folks who want to curtail speech always think that they have the best of reasons for doing so, that national security depends on it, that compelling state interests depend on it. Everybody who wants to suppress free speech always thinks that. And the courts are there, and the First Amendment is there to say, no, you can't do that.
Right, and not to mention, in this case, with respect to COVID, it turns out some of the people whose speech they were suppressing, like Dr. Jay Bhattacharya and Dr. Martin Kulldorff, were more accurate when it came to COVID than the powers that be that were guiding the social media companies when it came to tailoring what speech was allowed and what speech wasn't.
You have that right again, and we should have heard more about that yesterday. So the doctor whom you're mentioning, the Stanford scientist Jay Bhattacharya, he and a few others wrote the famous Great Barrington Declaration, saying lockdowns are the wrong way to go here. We have a disease that is mostly, unfortunately, tragically, the death rate for older and ill people was much higher. Why are we locking down the healthier people? And that was a serious public policy debate that should have gotten much more play. Now, years later, most people are coming around to their position that the lockdowns were a disastrous failure, and yet they were suppressed. These were public policy arguments. They were dissenters. They were saying the current policy on COVID is wrong, and you're not saving lives, and that we live in a country where all of a sudden you couldn't say that. You couldn't have a public policy debate about that. That's not how you satisfy compelling state interest. You satisfy compelling state interest by letting letting the facts out and letting people argue and debate their opinions. And what we saw in 2020 and 2021 was exactly the opposite.
Well, we got you because this just came over the transom. What do you think the prospects are for Trump in terms of finding success with the defamation suit against ABC and George Stephanopoulos for his characterization of Trump in an interview he did with Nancy Mace that you may have seen, where he pressed Nancy Mace, a rape survivor, as to how she could support someone who was found to have been liable for rape in that civil case?
Yeah. Well, I tell you, when public figures like former President Trump try, and many others as well, try to sue folks for defamation, they run into a legal doctrine which makes it extremely difficult.
Actual malice.
Yeah, they got to show what's called actual malice, and folks sometimes don't understand that word. It doesn't mean ill will. It doesn't mean like somebody doesn't like somebody else. It means you have to show the person who libeled you actually knew that what they were saying was false when they said it. You almost have to show that. That's how high the bar is, and it makes it so difficult. And a lot of people think that doctrine should be changed, and a couple of justices on the Supreme Court have indicated that they might want to reconsider that. But right now, that's the law, and it makes any such suit extremely difficult.
He is Jed Rubenfield, of course, professor of law at Yale Law School. Bobby Kennedy Jr.'s lawyer, as we heard. An expert on con law and First Amendment rights. He's the author of The Interpretation of Murder. Professor Rubenfield, thanks as always for joining us. Appreciate it.
Oh, it was a pleasure. Thanks for having me.
Thank you. And he joined us on our turnkey.pro answer line.
Listen to Dan and Amy on your smartphone. Download the AM 560 mobile app today at 560theanswer.com/mobile.
Pure Talk believes in American values and that free should mean exactly that, free. Well, switch to Pure Talk today and you'll get a free Samsung 5G smartphone. Now, qualifying plans start at just $35 a month for unlimited talk, text, 15 gigs of data, and, of course, mobile hotspot. Just dial pound 250, say the keyword Pure Talk, claim your eligibility for your free brand new Samsung 5G smartphone. Start saving on wireless today and switch to my cell phone company, Pure Talk.
And Doug.
Being a spokesperson's easy, kid. Just say, customize and save with Liberty Mutual.
Customize and save with Liberty Bibberty.
That's not it.
Letterby Mutual.
Mm-mm.
Liberty Musical.
Nope.
Lumberty, line.
It's 2 words.